more about statutory exemption EPA in California. I've talked a lot in the past and written about legislature, unfortunately, creating statutory exemptions Administrative Procedure Act, the APA. And the APA, of course, governs of California's over 200 executive branch agencies, commissions, etc., that engage in rulemaking. The purpose of both the federal and California APAs is public participation in the federal or the state rulemaking processes. Now, this is where the executive branch of our government engages in quasi-legislative. They adopt rules or regulations to implement statutes branch of government. Now, key to allowing public first, providing notice to the public of the proposed rulemaking itself, providing an opportunity to be heard during that rulemaking process. Statutory exemption from the formal rulemaking process that effectively precludes any meaningful public participation because notice would be the ability for interested parties to participate in and advocate for or against proposed regulations or other regulatory. Now, all regulations, as I said, are subject to the are expressly exempted by statute. Now, many observers is that they believe that a statutory exemption from the APA contrary to both the spirit of the law and the rulemaking process itself. Legislation that creates exemptions from the APA becoming much more prevalent in the California legislature. And these statutory present an unwarranted delegation of authority being made by the legislative branch of government. Instead of ensuring that the legislature by granting this authority to a regulatory agency, I think the legislature weakens its position towards the. In other words, when state agencies and departments engage in activities, those rulemaking activities should have an appropriate check and that the general public, particularly the regulated community, ability to participate in the rulemaking process. Now, while the office the OAL, the OAL oversees executive branch compliance with the statutory requirements of the APA. So track all the agencies that are totally exempt from the APA and to submit anything to the OAL in that regard. There are agencies and departments that are entirely exempt due to a statute. For example, the California Lottery Commission has an exemption. Commission as a result of an appellate court decision in this to the APA as it existed in 1974, which is when the FP was created by the voters by Prop 9 with the enactment of the Political Reform Act. Of course, the legislature could subject the FPPC to the current version of the APA. Now, community colleges and the universities have their own rulemaking processes and there's only a partial application of the APA to the public PUC, as well as the Worker Compensation Appeals Board, pursuant to Government Code Section 11351. There are all entities whose rulemaking activities are not subject to review. For example, the regulations of the Commission on State Mandates review. This means that the OAL cannot ensure that it has complied with the APA's requirements. While there's not yet a statutory exemptions, we're aware of over 200 partial and program or provision-specific APA exemptions in state law. And by my count, that's simply too many of them.